It's about to be a year since Harith Augustus was shot right here by Chicago police on the corner of 71st and Chappelle in July of 2018. And here we are approaching July of 2019, right here at this store, where Chicago police stopped Harith Augustus on the basis of nothing more than him having a bulge, what appeared to look like a gun. Take a listen as Superintendent Eddie Johnson details what happened.
So what were the officers doing? Because when you see the video, it looks like they were doing a foot beat. The patrol, they're walking behind them, and they noticed something about it. Can you describe what they were doing?
Yeah, so that particular area around 71st and Jeffrey, we've had several conversations. I know the Chief of Patrol, Fred Waller, and myself have had several conversations with the community and the elected officials around there regarding violence. So they asked us to put foot patrols over there to decrease some of that violence, and the Chief of Patrol did that. So yesterday, those officers that you see were actually on foot patrol. When they see the individual, they see what they think is a holster and gun protruding from underneath his T-shirt. And that's what brought them to stop him. They stopped him to question him, and then, you'll see on the video what transpires next.
There's in one of the papers, a friend of this man said that the police had stopped him because he was selling loose cigarettes. Is that true?
Like I said, we'll have to let the details of the investigation. I just told you what I know right now. So I don't want to taint COPA's investigation because I have confidence that they'll do a thorough one, and then we'll move forward after they make their recommendation.
Was a holster recovered as well?
Yes.
Okay.
Superintendent, did you, without memorizing chapter
Well, in your view, if an officer was going down the street and he saw an individual as to whom he had no suspicion that a crime was being committed, had been, or was about to be, he said that guy looks like trouble for anybody who has anything to do with him. So he goes up to him and he says, "I want to talk to you." And because he has reasonable suspicion that the individual looks like trouble, he pats him down. Is that a good pat down?
Well, he would also have to possess articulable reasons that a reasonably prudent person would be satisfied with, that this person is an immediate danger to.
Well, the individual gives him mean looks, and he has a bulge of something on his hip.
Well, that could very well support a pat down.
Then you are doing away with the first Terry factor. There are two factors you've recognized. One, reasonable, articulable suspicion that a crime is afoot, and two, that the person is reasonably suspected of being armed and dangerous. Your answer to Justice Souter suggests that you don't need the first one. You don't need to have any suspicion that a crime is afoot. It's enough for you to reasonably suspect that the person is armed and dangerous.
What I'm suggesting, Justice Ginsburg, is that the first prong of Terry is much broader than just suspicion of criminal activity.
No, but in my hypothesis, there was nothing that would satisfy the first prong of Terry. There's no lawful traffic stop. There is no indication that the individual has committed a crime or is about to or is doing so. So Terry 1 is blank in my hypothesis, and you nonetheless conclude that as a result of dirty looks and the bulge of a probable gun on the hip, the officer can in effect initiate the action with the individual and pat him down.
Oh, what I'm suggesting, Justice Souter, is that in the officer's community caretaking function, the officer is authorized to approach an individual that he thinks is trouble. And in the course of asking neutral questions, if the officer believes that this person is immediately dangerous to the officer, then a pat down would be appropriate in that instance.
Doesn't the officer need justification for a stop, for a Fourth Amendment seizure, whether because of a traffic violation or because of suspicion of criminal activity? And then, in addition to that, reason to believe that the person is dangerous. I thought that was your argument.
Well,
in the context of a traffic stop, you don't need, as to the passenger and the driver, you don't need suspicion of criminal activity. The person has been seized as a result of the stop. And then if you add on to that the reasonable suspicion of danger to the officer.
I know you guys are like, so what's the point to all this, Mike? The point is that we cannot just simply say that the people need to comply with the police and that's it. It is ever more incumbent that our nation's law enforcement not only protect themselves. We understand they have to protect themselves, but they have to adhere to the constitutional guarantees and protections afforded to citizens of the United States by law. After all, it is their job to enforce the law. Illinois was the last state in the Union, the last state to permit itself and its citizens to protect themselves carrying concealed firearms, having enacted the legislation in July 9th of 2013. But the question becomes, can we ever live in a society where the bulge of a gun is the new Terry? You know, you might have paid attention or you've seen or you've heard this addressed in Arizona versus Johnson, 555 U.S. 323, 2009, where the argument by the majority of the justices, they rejected the notion that the bulge or even a strange look, absent any other indicators of crime, being afoot or having been committed, was justified to meet the first test of Terry stops under Terry versus Ohio. You know, I often ask this question. What if Harith complied? If he would have complied, he would have likely been arrested. And given certain facts or certain circumstances, the case could have reached the United States Supreme Court where the justices would have likely granted certiorari to answer a specific constitutional question of the bulge being enough justification to stop someone, and would furthermore probably hold the Chicago police liable for his subsequent death under the fruit of the poisonous tree argument, otherwise known as the exclusionary rule. There were two cases that established the exclusionary rule, being Weeks versus United States, 232 U.S. 383, 1914, and the United States Supreme Court case of Mapp versus Ohio, 367 U.S. 643, the 1961 case that applied the Weeks case, the exclusionary rule, to the states. In order to achieve justice at the national level for all citizens, it is incumbent for persons under police authority to comply, so that a judge can rule on the legality of the incident and even the reasonableness of the officer's conduct. Finally, Johnson versus United States, 333 U.S. 10, 1948, the court opined that the point of the Fourth Amendment, which is not often grasped by overzealous officers, is not that it denies law enforcement the support of the usual inferences which reasonable men draw from evidence. Its protection consists in requiring that those inferences be drawn by a detached and neutral magistrate instead of being judged by the officer engaged in the often competitive enterprise of ferreting out crime. This is Instructor Mike, and you've been trained.